All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for June 3rd of 2024. Brad, go ahead. Take us away.
Okay, first of all, everybody take a deep breath. Today is some great cases. At least two of them are great cases. And they're complicated, they're exciting, they're difficult. It's perfect. So first, I want to start in Nashville. This is a case you posted last night. And this has so many layers to it, right? I mean, this has got so many layers. And as I'm reading through the complaint and your recitation of it, that's not where I thought we were going. So let's start with some generalization of the allegations. This is just a lawsuit. It's not a decision. These are allegations. So we haven't heard from the other side yet, as we've said. But basically, this is brought by a person who's a paramedic with a fire department who's on the ambulance. The department contracts with the jail and responds to the prison to take prisoners. Now, I've actually lectured on these topics, and it's a very difficult topic because it's state by state. But I think I have the answer, but to part of this, which is not what the case is about, but you'll see. So he goes to the jail, he goes to the prison, and the prisoner who, because the nurse called for him to come, and he's going to transport the person, but the prisoner explains, I don't want to go. And the prisoner is competent. And so the question then is, which is not the issue for this lawsuit, but such a great issue.
It is.
But it isn't.
It feeds into it.
It does. So, and then the question comes up in the paramedic's mind, wait a minute, he's competent. And then the other question of whether somebody can refuse care is, do they have the capacity? And so he says, listen, you're just a prisoner. You still have the capacity to make decisions. And he says, I'm not transporting the person. So that happens. I'm going to kind of summarize this together, but that happens twice, right? Because he transports the person. There's a big argument about it. He asks his chief, do you know anything about whether whether prisoners have no capacity? He said, I'll check. He does his own research to whatever that's worth. He comes back with, and by the way, I agree, prisoners do not lose the right to refuse their medical care. Maybe they lose the right to vote. Maybe they lose the right to hold office. Felons can run for president, however, but they don't lose the right to say that they don't need medical care. You can't impose medical care upon them without their permission. Now, I've also said, and I just want to throw out, but if you're just transporting someone against their will, here's the thing. You personally, right, could be sued, and it matters here. You personally could be sued for kidnapping, false imprisonment, right, violation of due process and civil rights, not due process, but civil rights. So when a paramedic says, I don't want to violate your rights, even though I'm told to do so, I personally believe, if this is all true, that this medic had a personal stake in not being sued because, take it one more time or one step farther, a paramedic who violates someone's rights, violation of rights might not be indemnified under insurance or municipal coverages. So that person could end up being hung out to dry on their own.
Well, there's a couple of possible legal ramifications for transporting somebody against their will. And one of them is false arrest. That's the state charge of false arrest. I don't think they can make a case for that if the guy's already in custody. How can somebody be falsely arrested as long as I'm assuming that a prison guard is going to accompany him to the hospital and so on. So he's still in custody. So, but the civil rights part, I don't think goes away. And I think you're right on that. There's still that potential for a due process or Fourth Amendment, whatever, whichever realm you go under, that basically his constitutional rights have been violated.
Right. So all that said, Curt and I are just saying, right, that we think this guy had a valid reason to make his point if this is what happened.
Right.
Then comes the issues, right? So this goes back and forth between the chief, the jail gets involved saying, we have the right to do this. You have a contract. You have to transport. The chief apparently is alleged to have back his guy, right? Now, to me, most people say, oh, just transport them, don't worry about it. But if you're put in the position where you have to violate someone's rights, maybe, right, you have a justified concern not to violate someone's rights. So Now the issue happens. And this gets a little confusing. But basically, let me jump to the end and then I'll fill in the middle. Let's try it this way. In the end, he's terminated because he's a no cause, no show at work, right? Now, why is he a no cause, no show? He's a no cause, no show because he gets somebody substituted previously to work a shift for him. Then he's accused of not doing it the right way, etc. But ultimately,
let me give it to, okay. So what we have here is within just a couple of days of that verbal argument with the sheriff's office, which probably created a political problem for the fire department.
Oh, yeah.
But at any rate, a couple of days after that, he's agreed to work for a female medic. So he's going to substitute for her. She, in turn, is going to substitute for him so that he can go. He's a Marine Corps veteran. He wants to go with his platoon. Every year, his platoon meets at Arlington National Cemetery to honor one of their platoon members who was killed in action. So he agrees to substitute for her on January 26th. She, in turn, is going to substitute for him on February 16th. So that's sort of the plan. And then what happens is he shows up on January 26th and he gets a phone call from his mother. Apparently his father has dementia. He's trying to kill the dog, or he's thinking about killing the dog. And so he goes to his chief and says, "Chief, I got a family matter. Can I get out?" And the chief said, "Yeah, go." He says, "There's not going to be any consequences to me going out." No. Just go. He's just leave. Okay. So based on that representation, he then leaves. They've got to get somebody else now to fill in for that. And then after the fact, other chiefs get involved and they're not happy that he didn't work that shift. And they in turn tell the other person, I think her name is Christy Farrell, who was supposed to substitute for him on February 16th, "We're going to dock you a day." I think she had to use vacation or whatever for it. "And you are prohibited from working his shift on February 16th. So now, which I don't, that's going a little right beyond normally, I would think. But again, I can't.
And then word spreads around the department about this guy, and nobody will take his shift, so he can't get anybody to, right, as an alleged result of word spreading, he can't get anybody to fill his shifts.
Yes, exactly. And again, he's relatively new. So he had started about 6 months before this, or not quite 6 months, but he started in October of 2023. So it's not like he is a 20-year veteran. He was relatively new. He had previous experience as an EMT and a medic, but he started in October of 2023. So no one would sub for him. He went back and forth with some of the chiefs, and I guess he made the decision, the heck with it, I'm going to go to Arlington National Cemetery to be with my platoon, and he was terminated when he got back. So now he's got to make the connection. I'm sure this is where you're going. How do you make the connection?
Yeah, and so let me jump to, he's alleging one is a violation of the Tennessee Public Participation Act, which is basically it prohibits retaliatory terminations. I've not read that law, it must be very broad. And then the other one is common law retaliation discharge. I guess that's what I would do too, right? But he could have gone farther. The Civil Rights Acts not only protect the victims, but protect people who protected the victims. You can't retaliate. So I'm surprised, and maybe these special, laws, Tennessee laws, kind of encompass the same thing. But he had some federal claims he probably could have made saying, I didn't want to violate their civil rights, and look what happened to me.
Right. And I notice it was filed in state court. And often when I see a case like this filed in state court, I'm thinking the attorney does not want to go to federal court. The attorney is trying to keep it out, so he's got to find some state law claims. And again, I didn't look at the statute either, but I'm assuming it's a whistleblower type of protection.
Right.
And his whistle, the whistle that he blew, had to do with the sheriff's office or the sheriff's department who runs the jail, requiring the inmate to go when the inmate does not want to go. So basically violating the inmate's rights.
Right. And you can I'm making this up, obviously, but you could see like a phone call between the sheriff and the mayor or the chief or whoever saying, this guy's got to go. We'll drop it, but we're not tolerating this. Right. You could see that kind of backdoor. And then only 2 days later, you kind of gave him a reason, a way to.
And I don't know this guy. I do know a lot of the folks in Nashville. So let me put my management hat on. Who is this new firefighter to create this political problem in this organization that we've got to get along with them? We've got to get along with the sheriff's department. So I can see that part of it as well. Just saying, you know what, he's new, but he's going out researching the law on his own, and so I can sort of see from the department's perspective where they might be motivated to do it. They might not be thinking about it in terms of, holy cow, this guy's got a whistleblower claim teed up against us. Why are we screwing with him? But
And a lot of our viewers got to be saying, okay, forget the termination. What's the answer when we think someone's, when we're being told to violate someone's rights? And I'm trying to think how I would act, which probably is not the right model, right? But I would
not be confrontational on it. I think being confrontational about stuff doesn't get you anywhere. Right. And what you've got to say, explain to them is, I've got a concern about this. Let's see if we can work it out. Now, again, confrontations can be started by the medic. They can also be started on the other side as well. So it's, you've got this conversation going back and forth, but getting in an argument with people on runs is not productive.
It's not. Now be clear. This is different than, because you and I speak about this a lot. This is very different than a cop who says, listen, I need to sedate this person, so give them some ketamine, even though it's not within your protocol. That's a very, very different scenario. Don't mix these two, because that happens a lot.
Right.
Okay, so in any event, that's going to be very interesting to see how it happens. It's, it's a question of fact. Whenever I take a case and I'm like, is this a law question or a question of fact? This is a question of fact. Why did you terminate somebody? But it is so close to the time that it's going to kind of lean towards looking like the employee is right because it's so close in time.
And I left out, in my quotation from the complaint, I left out some of the discussions that happened between some of the chiefs about, they weren't happy with the way that he wrote up his report. They weren't happy that he cited statutes in his report. They weren't happy that he apologized to the first person he transported for violating his rights.
Right.
And so again, there's a little bit of maybe escalatory behavior that they may have sensed on this guy's part, that we're probably better off without him. And that, I think, led to that.
Which isn't the right reaction from management, if that's the case.
If that is the case. No, especially when somebody's got a possible whistleblower claim teed up here.
Yeah. Yeah, that's a good one. Okay, so next, let's go to North Carolina. Now, this one, I know you're going to take a hard stance because you're obviously said it in your blog, but you take a hard stance against this social media policy. This is a good example, frankly, and this is not a small area. I mean, we're in North Carolina here, and we're in a city with there's the defendant, but social media stuff, I'll quote you, there's lawyers who either know it or don't. And when they don't know it, they give bad advice. What I will say, of course, is the lawyer suing certainly knows the law pretty well. So I don't know if you want me to do this, if you want to do this.
It's up to you. I mean, social media is such an important issue. I think it's the number one reason. I actually should do the numbers, but in terms of what's causing firefighters to get terminated, social media is playing a major role, especially since 2016 and the death of Michael Brown. It's just exploded. It was bad before that. It just exploded. But the political rhetoric in social media to begin with, take firefighters out of it, is just overwhelming. And now firefighters jump in both feet and they say things, and it just creates problems. So this particular firefighter apparently made a number of postings. He had been called in, and unfortunately, the department told him, at least as far as the complaint goes, that he was told to stop sharing his political views.
Right, and these are political posts, which clearly means you're a private citizen.
Bad news. Political views have great protection under the First Amendment. I mean, this is just, you're playing with fire here, and often fire departments don't have a well-drafted social media policy, they're going to try to charge somebody with conduct unbecoming, or in this case, they just fired them without really a full explanation or a full investigation.
And by the way, just a little bit more substance to it. The comments he's making was not about his fire chief or fire department. It was about the county sheriff. And he's expressing views about the county sheriff, who's an elected official and not his boss, right? So they're going to have a hard time, as a lot of our viewers know, the Pickering test, right? Mm-hmm. One of the first steps is determine, is he speaking as an employee in his capacity as an employee? And if he is, then nothing he's saying is protected. Or is he speaking as a citizen, which on a matter of public concern? And you're speaking about politics, about somebody who's not your boss. I'm sorry, you're speaking as a citizen on a matter of public concern, unless he's arresting firemen or doing something. This is, he had the right to say
the thing, if the city had a well-drafted policy, and one of the areas here is that you can say that if your speech causes actual harm or disruption to the mission and function of the fire department, and that's the key language that you want to have in the policy, but actual harm or disruption to the mission and function of the fire department. Now, by the way, whatever that means, okay, that's the language the U.S. Supreme Court has used. That's why I incorporate that into our policies.
Sure.
Because then the Supreme Court say you can't use that language in your policies. It's your language, okay? Yep. But if it causes actual harm or disruption to the mission and function of the fire department, and you have that in the policy, then you can discipline them for violating the social media policy, okay? Now, there's a fact question about whether or not his post actually did cause actual harm or disruption. Well, there's a factual question, but maybe it caused a rift with the sheriff. Maybe it caused a rift between the agencies and stuff. So again, I don't want to get into whether or not that could or not. If you don't have the social media policy and you're going to try to charge him with insubordination for not following your unconstitutional orders to him, to not talk about politics, you're going to lose that case.
Yes. Yes. And that's exactly what happened here, right? His employment's terminated because he's alleged to have, violated a very poorly written policy. I apologize to the people, but it is a poorly written policy.
Well, and I see so many social media policies when I review a fire department's policy in this regard. And it says, you cannot do anything to discredit, dishonor, in this case, I'm looking at it, discredit, dishonor, or embarrass the fire department of the city. You just can't. You just can't have that kind of language in there.
No way. No way. And that, and again, if people aren't familiar, and look, just say, oh, I know the Pickering test gets you like 4% there, right? Because the courts then, so many court decisions beyond that then say, what the heck is it? What's the test? In what order? What's the most important? And where does it end? And but it, please do not just have your run-of-the-mill person create a social media policy. Now, that said, I can promote Curt and I again because, as some of you know, and many more of you will know soon, and I think our website and our program will go live this or early next week, Curt and I are doing a must-have policy service for $1,500 a year, where you will get a video from Curt or me or both of us and a model policy, and you will be told why it's important, how to customize it, right? But you're certainly not going to get something like this. But that service,
you're going to get a top-notch social media policy when it comes time for the social media and digital imagery and all the other cutting-edge things that are getting fire departments into trouble these days.
Right, and EMS agencies. And so you will not put yourself in this, and not to be the salesman, but for $1,500 a year, you're probably going to, prevent $100,000 of litigation.
Yes. I think the court costs alone, just filing the suit, you're there. So
be knowledgeable, be prepared, and avoid these issues. Okay, just really quickly. So as we talk about $1,500 a year to receive model policies and videos, and you're going to Nebraska. You put this in, I think, because you want people to understand. In many types of lawsuits, FLSA, FMLA, civil rights, many and a whole bunch of state statutes, they say, listen, you the victim get a certain amount of money. But frequently we recognize that their damages could be $1,000, $2,000, right? But it takes a lawyer hundreds of thousands of dollars to vindicate you. And I have a great court decision. It's in a case where a firefighter was kicked out of the department. He was a volunteer, so there's no real loss in money, But the court says, it's great language. The court says, if we don't award attorney's fees here, nobody will ever take these cases and nobody will ever protect the rights of these members. So courts need to, and I argue this to the courts all the time, like, please pay us. But it is, even like in disciplinary cases, my fees could be $30,000 for a disciplinary case, right? So who has that for a volunteer job? Here, what happened is we have a sexual harassment decision, and they wanted not only damages, but also attorney's fees. And attorney's fees can be more painful to the losing party than the damage they caused to the victim. And here they have awarded over $700,000 in attorney's fees and costs. Now, they wanted 1 point some odd million, but the court, I haven't read it, but they probably reduced it down to the average rate and average reasonable time. And, but this is still a penalty for the losing party. And that's why Curt and I constantly say, you better have a good policy. You better just avoid the issue. Is it worth the well over $1 million that this thing cost them to lose? There are better ways to go.
And this case, it's not just one lawsuit, because there were 2 captains involved in this as well who ended up filing lawsuits, and they both either got settlements or prevailed. Yep. So the whole thing, several $1 million that it cost this city. So, and I'm not saying anything about the merits. I don't know whether or not it was a meritorious case or not. All we know is the dollar amounts, but you can see each of those bullet points in there. Nebraska firefighter files sexual discrimination suit court. Those are separate postings that we've covered, never mind all the ones that are out there. So a great deal of time and effort in here. I want to kind of just go over one thing, and I think it's an important philosophical approach to attorney's fees. Okay, when you think about it, when Congress is going to enact a law such as Title VII, which allows attorney's fees, Congress has a choice. We can either create a bureaucracy like they did with OSHA. And if someone is hurt at work and OSHA comes in and does the investigation, you don't have to get an attorney for that. OSHA comes in, OSHA has a bureaucracy, and they handle it. It's very expensive to do things that way. So what Congress does in some cases is they say, you know what, we're not going to burden all the taxpayers with having to create a bureaucracy to manage sexual harassment or the FLSA or whatever. What we're going to do now is authorize someone who feels they've been wronged to go hire an attorney, and then the attorney can get the attorney's fees. One way or the other, you're either going to pay for a bureaucracy like we have with OSHA, or you authorize the person to go get a private attorney, and then that's where the funding is going to come from. Is basically the losing party is going to end up having to pay. So there's a philosophical, because I know there was a couple of comments in social media about the greedy attorney not being happy with whatever it was, 1.8 million that he asked for, and poor guy's got to settle for 700,000. But there is an awful lot of expense associated with bringing a case, especially a complicated case like this one.
Well, and let me say this: like, there are 2 sides. There's the insurance view side, and then there's another side, which is the insurance company is basically like, look, if we could settle this for court costs and attorney's fees, that's what we'll pay, right? And we're going to have a confidential, you sued, and we're just going to pay you off and your lawyer off because it's cheaper than what we're going to pay to win. And insurance
I wonder what happened here in 2018 if they had just done that.
Right. And in this case, maybe it would have been cheaper for them to do. The problem with that, however, because I'm on the other side, is if you've got a shitty case, I'm going to defend it. And I'm not going to pay it unless the insurance company says we're going to pay it no matter what. But generally speaking, I'm going to fight it. And I'll give you an example. Recently, last week, I've been in a trial. It's still going. And just for 3 days of trial, our bill is over $30,000. We've got a lot of attorneys sitting in trial. We've got, 10-hour days. There's no lunch, that type of thing. And yet they probably would have settled for less than that. Right. But if we just give in, then these plaintiff attorney shops are going to be like, oh, we'll sue, they'll pay. Right. On cruddy cases. So that but the insurance industry keeps flipping back and forth. We're not going to pay, we're going to pay. We're not going to pay, we're going to pay. And I'm not criticizing them if they really thought they could win. That's not what, right? So viewers, that's not what Curt and I are saying. If you think you could win and you just happen to lose, so be it. That happens.
Well, and very often the plaintiff in these cases is not the nicest person around. Very often. I haven't met this person. I have no idea. She might be a wonderful person. I don't know. But very often they're a difficult person, but at the same time, they're being harassed. Maybe it's because of their gender. Maybe it's because of something else. Maybe it's because they're not a nice person. Whatever it may be, it still is harassment, though, and they can make the case. And so,
or they're going to try to make the case.
Or they're going to try to make the case. So again, sometimes we got to kind of, take a step back as attorneys. We got to take a step back and say, all right, the chief is saying that the person's creating the problem themselves. Am I going to be able to properly construct a defense? Right. Or has this person actually been harassed? Maybe it's not because of her gender, but she still is being harassed. They're going to be able to sort of confuse the issue, make it appear that it was because of their gender, and we're going to lose.
And I will tell you 100%, I won't give any more comments because we're still in trial, but 100%, that's the issue in our case. One person says, I'm terminated because of this, and it's protected, right? And the other said, no, we terminated you because of this. And it's ultimately going to be a jury or judge question. What does the record show? What's more likely? And it's a gamble every time you do it. That said, I'm still of the belief that if you can fight it, be aggressive about it. And, to the would-be attorneys out there or the would-be plaintiffs, you come to our area, we're going to fight you. If we're wrong, right? Mm-hmm. And we'll pay it. We'll be done. But if there's really a legitimate other side to why you were terminated, not promoted, demoted, whatever, well, then maybe, as Curt's saying, you just don't want to recognize it. We're going to fight that. But you can always find an attorney to sue anything. And I think the attorneys have to fight it. So to the comment of greedy attorneys, people have no idea what malpractice costs, what office overhead is, court costs. We just paid $1,000, right? We paid $1,000 to transcribe a 2-hour meeting. Okay, well, they got paid $1,000. We got to come up with that. This isn't greedy attorneys fees. $700,000, yes, is a lot, but is it a lot if it was going on for years? And the attorneys had to front that money without any expectation of getting back. That's a huge risk. So I'm going to defend the attorneys naturally, but anyway. Okay, this one also very interesting. I've not seen anything like this, although I got to tell everyone I can't wait to the last case we're getting to after this. But we're in California. We have firefighters are claiming that they're being retaliated against for being critical and voicing concerns about the management of the fire department. And that as a result of them voicing the concerns, the retaliation is they're not hiring and filling spots. And thus, they're forcing the firefighters to do an excessive amount of mandatory overtime. And, it's interesting. It's a great case. I think if true, I think it falls on the firefighters' side, is my 2 cents. On the other hand, the employer could say, listen, you bargained. I'm assuming they bargained for minimum staffing, right? That's usually met with, okay, if you want minimum staffing, you're going to get mandatory overtime. I'm guessing, I don't know. But the employer could say, you wanted you bargained for mandatory overtime. We're just telling you we can't fill it. And I want to juxtapose this case with the one last week where they couldn't get people to stay or get hired, right? And because they claim bad management, nobody wants to work here, morale's horrible. Right. And there's excessive overtime, presumably, because they can't hire anybody.
Yeah.
Here, they're claiming it's intentional.
Right. Well, I'm going to tell you, I lived this. This was a problem in Providence. We had a finance guy, and I think this guy, Bruce Moe, the mayor, probably went to the same school that the guy in Providence that was doing this. He was a finance guy that he was in and out of private sector, public sector, bouncing around. But I remember being a firefighter and then moving into the front office. When I first made battalion, I moved in the front office, and now I'm privy to a lot of those meetings. And I remember meeting with him, and he had a figure for what it cost for a firefighter, and it's 1.94. So here's how that works. Okay, if you have a firefighter that makes $100,000 a year, his number for budget purposes is 1.94. Okay, so basically it costs you $194,000. In order to pay that firefighter $100,000 a year, is going to cost the taxpayers 1.94. $194,000 to have that firefighter work 40 hours a week. Okay, that's no overtime, but that's all of his benefits, that's his vacation, sick leave, everything, but $194,000. And he said, I can save the taxpayers 44%. And that's not actually 44%, but
right.
basically by not filling a position, and the position is going to cost me 1.94, $194,000. I can fill that position 7 days a week, 24/7, okay, or actually, one shift, 40 hours a week. But I can fill that position for 1.5 by paying people overtime to work on it. And therefore, that difference between 1.5 and 1.94, the taxpayers are saving money. Okay, so that's sort of issue number one in this scenario right here, okay, is that the city is saving money by making the firefighters work overtime. Okay.
And if that's true, they win. The city wins this case.
They win. They absolutely win. Okay. And issue two here is that when somebody complains about it, it could be the firefighters that complain about it. It could be taxpayers. It could be whatever. Basically, you look at, firefighter Pinsky made $250,000 last year. Look at all the overtime. What a greedy pig.
Yep.
Firefighter Pinsky is. Look at firefighter Barone. Look at all the overtime. He's $275,000. This is outrageous. The mayor goes, yes, the firefighters are pigs feeding at the trough. And he doesn't say, we're doing it to save money.
Right.
They're doing it to have the public upset with the firefighters.
And by the way, mandatory overtime, not even their choice.
It's a win-win for the city.
Right.
Because the city's saving money and they're blaming the firefighters. And this is exactly what this guy was doing. By the way, one more thing. Yeah. I was contacted by a colleague who was a finalist for the chief's job back in 2018, when this guy became the city manager. Or at least, he was going to be calling the shots. And she was telling me that this guy hated the firefighters. You're interviewing a new fire chief, a potential new fire chief, and she said he hated. It was very clear that he hated the firefighters.
Wow. Okay. And so that goes into, she could be like witness number 10, but that goes into the
client confidence. I cannot disclose the identity of this person, nor would I.
Right. And you've changed the sex to protect the innocent. But if it's true that it's not a fiscal decision, but it's a retaliatory decision that you could have hired, you just took no effort to hire. And to me, I for some reason, I always think like, how would I win this case or defend this case or whatever? And the city is going to have to prove, or the firefighters will have to prove, that the city took no effort or took a reasonable effort or any effort to hire new firefighters.
They did the opposite. They did the opposite.
Or tried not to hire firefighters.
They made a strategic decision not to hire and to use overtime to fill those spots rather than hire additional people. And,
that may violate OSHA's safe place to work standard and the general employer duty standard. Maybe that would be a different way to handle this if it was me. Mm-hmm. But that's all of what this comes down to is jury question, not judge question. So pull out your quarter, and that's the risk everybody's taking, right? Because you don't know how a jury is going to find. And look, the city could bring in a million other managers to say, we do the same thing. It makes sense. And they agreed to overtime, so we're going to do it. And they're not getting hurt. Look at all the money they're making. Every win-win for everybody. All right, until somebody gets killed on the job for being too tired.
Somebody wants to go home for Christmas, and they haven't been home since Thanksgiving because they can't go home because they're being ordered to work constantly.
Right. At some place, it's not safe. But that said, this is a very difficult lawsuit. Definitely is jury. I doubt it's going to settle because you got the city presumably already angry and defending its right. But maybe calmer heads will prevail. The city will understand that it's not a safe thing to do for firefighters. I am not right. We are not supporting mandatory overtime as a method of this workplace. I think it violates a safe workplace. Yeah. I think you can't ask people to work that hard without proper respite care, et cetera. Okay. Anyway, great case though. Lastly, Curt posts this to the viewers. Curt posts this, and I then have to spend hours researching it because I'm so interested in it. And so let me give you I'll give you very simple facts. I'm going to make it very simple, but the legal question, this could easily go to the United States Supreme Court. Easily, this probably should go to the United States Supreme Court. So here's what happened. We're in Los Angeles County. Los Angeles is a very progressive, whether you like that word or not, progressive city. And we have a lifeguard whose religious beliefs do not allow him to agree with the LGBTQ community or way of life. He doesn't believe in same-sex marriage, doesn't believe in homosexuality or bisexuality or anything like that. So LA wants the lifeguards to raise and lower the pride flag. And the government is saying, we want to speak, right? I'll explain that, but the government's saying we want to speak that LA supports Pride Month, Pride generally. So he refuses to raise and lower the flag because it's against his religious beliefs. So we've got government speaking, right, saying this is the message we want to promote, and an employee who says, I don't want to promote your message. It violates my rights. And then the employee says, and by the way, I have a reasonable accommodation, even though that may or may not be the exact standard here, but there's a way you could easily accommodate my First Amendment rights to, my beliefs. So he's filed a complaint for religious discrimination and retaliation. He claimed that his supervisors breached his rights and on the accommodation. They've threatened him. They threatened harm to his children, which is a little strange if that's true. And he was terminated, right? Or no? Or he's just forced to. Let's see. He was threatened by a much bigger person, a chief, who's alleged to be not only huge, but also skilled in martial arts. So I think he was threatened by him. I don't think he and he was told your religious beliefs don't matter, which may or may not be true, which we'll talk about. In any event, he was threatened. I don't think he was terminated from what I see. He's just filing suit saying I've been threatened over my beliefs. So here is as you look at that, here is
I think they started some discipline towards him, and then that's when he filed the suit, because all this is fairly recent stuff. This wasn't stuff that happened. Let's see. Yeah, it's over the last year. So,
yep. So as you're looking, so here's, look, the question is, whose right is supreme? You've got the government who has the right to speak. I'm going to explain that. And you've got an individual who's right to their legal beliefs. And I think I found the case that will address this issue. I'll explain it in a minute. But so the government has something called government speech. And when the government speaks as a government, it has the right to voice any message it wants. And it can voice messages. Now, the government, however, cannot. So that's government speech, and you can't even sue the government for their speech. They're protected, no lawsuit against them. But that's not what's happening here. But it's important to start with that rule. Here we have an employee who says, I don't want to allow or participate in this government speech. So I look at this akin to a couple things. This is how I tried to research it, because the findings of my research were very interesting. There was nothing I could find like this. So this would be saying, like, I don't want to salute the flag, or I don't want to do the Pledge of Allegiance, or I'm not going to raise or lower the flag. So I looked for 3 types of cases: refusal to salute, refusal to raise, refusal to lower. I couldn't find any case where and there must be one, by the way, but I couldn't find any case where a employee is saying, I'm not going to honor, right, my employer's speech. There are a lot of private party cases, which everybody's familiar with. For example, where somebody kneels on a football team during the national anthem and is terminated or benched, but that's private speech. Here, we don't have speech. We have the refusal to participate in government speech. So I couldn't find any case, which tells me, U.S. Supreme Court. Now, I did find that the government, and this is the United States Supreme Court, not so long ago, the U.S. Supreme Court said the government can raise a pride flag, and that's government speech, specifically saying the pride flag. So it's clearly government speech. Whether you can terminate an employee for not honoring or promoting your speech is the different issue. But I had a case where I cited another case, and the case was this. It was in New York State. The clerk of a village was, after the U.S. Supreme Court said that gay marriage has to be honored, and New York said gay marriage has to be honored, and the clerk, based on religious beliefs, refused to sign marriage certificates. Exact same issue, right? And the government, the mayor ended up signing them. So there's a lawsuit. I believe, I have to go back and look, but I believe the finding was for the government, not the employee, saying you got to do it, right? It's the government's job to sign marriage certificates, and you're ordered to do it. The mayor can't do it because it was the clerk's job, but ultimately the court generally decides on the government side of, you have the right to have the speech, and your employees have to adhere to it. If you don't like it, don't have the job. But
this is tough because, at what point does inclusiveness allow government to become oppressive to other people's views? Okay. And I'll give you one right off the front pages. Okay. What if there's a Jewish firefighter who doesn't want to raise the Palestinian flag?
Yep.
Okay. What if there's a African-American firefighter who doesn't want to raise the Confederate flag, that for whatever reason, government, his mayor, his fire chief is saying you have to, there's speech that it's one thing for the American flag that we should all rally around and unite. And it may be a symbol to some people that is objectionable, but generally, I think that's one thing. But when you start getting into speech that is
messaging,
then that's a different thing. And again, at what point are we, as part of our effort to be progressive, to be inclusive, becoming oppressive in that? And I don't think it's rhetorical. I don't think we have an answer to that, but I think that's at the heart of this. We went through this in Providence with the Gay Pride Parade. We had firefighters that were ordered against, they said, we've got religious objections. One of the firefighters on the unit that went had a religious objection. His officer took the position that he was going to try to protect his firefighter, and they were ordered to go to the parade. And here's another part of this, a unique part, but they were then harassed at the parade. But I could get into the details. They were, without question, and I'm by no stretch a prude, okay, but they were subjected to clear sexual harassment that was severe, okay, and they then could have probably sued just based on that. But now, in the weeks and months afterwards, their colleagues started making wisecracks, making jokes, leaving cartoons on the bulletin board about them that continued the harassment, and they ended up suing. So again, there's a lot at stake here. And I like you, I'm very interested to see, and I think it may take some Supreme Court decisions to give us some clarity here on at what point can government kind of go beyond our symbols, our national anthem, our flag, and get into some advocacy for different groups, and then require people, without allowing for an accommodation, to join that.
Right. And that's why I think they're going to the reasonable accommodation, saying, listen, you could have done this another way. Right. There's another way to get the flag raised and lowered that doesn't have to be this person. On the other hand, I kind of look at it as raising and lowering a flag, because this is where I would come down if I was the court. I'd avoid the whole thing. I'd say, is raising and lowering the flag, is that even speech? I'm not sure that's speech. And I'm not sure the raising and lowering is so burdensome.
It's not your speech.
Not my speech, right? It's not my employee's
government speech, but it's not your speech.
Nobody's looking and saying Brad's raising the flag, so this is what Brad believes. So frankly, if I'm the district court where this should go, is I'm saying, this isn't even really a religious belief issue. It's you're refusing to do what you're doing, and this isn't about you at all. Yeah. I just don't think it is. But it's an amazingly great case, but I think an employee does not have the right to refuse to honor the employer's directive. And taking this in the private sector, no, he's keeping the district, the prime sector. If we keep in the government, district attorney, right? A new district attorney is working for the DA's office. DA's office signs him a case, and he finds the prosecution of that case morally objectionable. Maybe it's an abortion-related case, whatever. It doesn't matter. He finds it morally and says, I'm not going to handle that case. I refuse. Okay, that DA, that ADA is getting fired and is going to lose the lawsuit, I think, on religious or whatever freedoms. You took a job, you took a job without any guarantee of we're going to honor all your beliefs. And there's no way for government as a practical matter to honor the beliefs of all their employees. We're not talking about honoring a disability, right? Or accommodating a disability. We're talking about you may be asked to do something which you don't agree with for religious or other freedoms. I don't think a government is expected to honor everybody's personal rights, personal beliefs. Unfortunate, but that's the only practical answer one could give. What are they going to say? Okay, everybody who's not mad to raise, because otherwise, think of it. They would have to say, we raise pride flags. And if you want a job as a lifeguard, you have to believe in the pride flag or be willing to raise the pride flag. That would never, right? They could never do that.
Right.
So I think
it's tough. And again, I think the way I've been sort of schooled to think as an attorney, go to the opposite side, go to find another metaphor for it. And again, an African-American firefighter being required to raise the
Confederate flag,
the Confederate flag, or a Jewish firefighter being required to raise the Palestinian today or the Nazi flag.
Right.
You know, I don't know. I say, you know, the rule we make for one thing doesn't fit over here. You know, like we come up with a principle. We try to make principled decisions. We make a decision over here. We come up with a rule that we think fits. Then you apply it over here and go, it doesn't fit over here.
Right.
So maybe we got to kind of rethink this whole thing.
Right. And, you know, take it one step back. What if he didn't care about raising and lowering the flag? He didn't want to sit under the flag. Right. It's just there. He doesn't want to sit under it.
He's at Station 8 and somebody's flying the flag at Station 10 and he's offended that they're flying it at Station 10 and he wants to protest that they're, you know. So again,
very difficult case.
Back, you know, at what point does insisting on inclusivity itself become oppressive? You know, at what point? I don't know.
And from the practical standpoint, getting a case to the U.S. Supreme Court is in the millions of dollars because it takes 3 courts to get there before you even get there. So, I mean, you're talking a huge amount. And I did 2 hours of work.
They've got the Thomas More Society back in the plaintiff.
Okay, because they're going to need it.
They're going to need.
But ultimately, I think government's interest is going to balance out. Imbalance is going to outweigh the personal belief. I'm not a constitutional expert. Maybe we're bringing Chip. But based on my research, I think this is going to weigh ever so slightly, but in the balance of the government. You know, he's not being asked to do anything more than raise or lower a flag. I'm not sure that so infringes on his beliefs.
How would you, what if you were required to go to a parade, participate in a parade?
I'm there. So I would, if I'm there to honor the department, right. And not the cause. And I don't think marching means, look, non-Irish people march in the St. Patrick's Day parade, right? I don't know that you are speaking, if marching is speaking and promoting a belief. I don't know whether it is or not. But but a parade isn't part of so entwined with part of your job. And I'm not sure raising or lowering a flag is that important either, frankly. But what if they painted the flag on the side of the guardhouse? Right? He's not going to sit in it. That would be a different issue. Now, I'm not even going to sit there where I'm supposed to be on duty. I just think in this case, raising and lowering flag probably isn't, it's not like saluting the flag, right? It's removed from that. So I don't know. I'm just guessing, and we'll find out in about 5 years.
Yeah, maybe.
Yeah. But if anybody who's watching this is involved, especially the attorneys, we'd love to hear your argument. I'd love to see your memos. And, you know, when
we can do it. If you want to come on and talk about it, we can arrange that as well.
I'd love it. That would be really interesting, either side. But this is a great constitutional case, and it's a great case. And that's it for the week.
All right, that's it. That's going to wrap it up for another week, another edition of Fire Law Roundup. We'll see you all next week. Brad, thank you again. We'll see you.